right, we are live and recording.
Welcome to the Appeals Court. I am Justice Mead. With me today are Justices Willahogen and Justice Massing will be the panel for this case. These cases have been paired and combined for argument, and I will call them both now. The first one is 2020 P 738 Kettlebrook Loft LLC versus all other unit owners of units at Kettlebrook Lofts. And this other case is 2020 P 739 Trustees of Kettlebrook Lofts Condominium Trust versus Kettlebrook Lofts LLC and others. And I believe that Attorney Goodman is going to start off. Goodman, excuse me.
Thank you, Your Honor. If it please the court, I represent the appellants in case number P 738 and the appellee Kettlebrook Lofts LLC, the declarant of Kettlebrook Lofts Condominium in Worcester, Mass, in case number 0739. In case 0738, my client sought injunctive relief against the then trustees acting as such because we claimed that the master deed was properly amended to extend development rights and added units and appointed a new board of trustees. Case 739 challenged the amendments and replacement of trustees, claiming development rights expired and mortgages on development rights had expired. My argument in both cases will be duplicative, and so with your permission, please let my argument stand for both cases. When I was hired to extend the development rights of the declarant with only 3 days to go before expiration, I found the provision most on point. Paragraph 11A of the master deed, entitled Amendment of the Master Deed, contained a reservation of rights.
Can I stop you just at the beginning? Two things. There are two cases, and since we're going to be, there's document intensive, can we agree which appendix we're going to be referring to? Are we going to refer to the appendix in 738 or 739?
Because both of them are pretty much, well, they're not
page numbers.
They're not, because they were two different cases.
Yeah.
If I refer to the appendix, Your Honor, I think we should refer to the appendix in 739.
All right, 739. Good. Okay, agreed. And just to give us, before you get into the weeds, can you give me a big background, like a big 30,000 foot here? If the judge's decisions are affirmed, what happens? And if you're able to convince us to reverse them, what happens in terms of your client's development rights?
Okay. If the decision is affirmed, then the development rights have expired and my clients have no further right. And
do they still own 5 units?
I beg your pardon?
Do they still own 5 units?
I don't know if they own 5 units anymore, but I know that they own at least 1.
Okay.
And
they're just okay. Sorry.
Okay.
And liability on the, sorry, I don't mean to, I hope that your answer will include what the practical effect of our decision would also have on the indebtedness.
Yes. Attorney Tinsley does represent the mortgagees, but my opinion is, and you may disagree with me, but my opinion is that the indebtedness still remains, that it is a dormant indebtedness, but as it was placed on the property before the master deed was ever filed, there was an underlying lien against all of the property. And it's my opinion that in the event that anyone should revive the development rights as is provided for in Chapter 183A, Section 5, that the mortgages would have to be satisfied because they ought to be revived as well. But that's
so I guess what I'm understanding you to say is that your client's development rights, even if we were to hold that they expired, given the provisions of the master deed, it doesn't mean that in the future, someone else may not be able to come and develop the remainder of the property. Is that correct?
That is correct.
And how would that occur? Would that occur through a vote of the trustees or what?
The trustees have the right to revive the development rights under Chapter 183A, Section 5. I think it's 5C. If they revive the development rights and sell them to someone else, the statute uses the term revive. Okay, it breathes life back into the development rights, even though they might sell them to somebody else. And I'm suggesting that the mortgage itself, which was underlying everything, is just dormant. It's not dead, even if my argument should be denied.
Okay, so can you maybe give me a little bit of understanding into just as a matter of facts on the ground, how your client ended up in this situation? And the 7-year deadline didn't come as a surprise. What happened? And as a practical matter, why wasn't this finished, or why was there not some? And if they were as close as you argue to completion that they were, what happened here instead of just finding some accommodation that would have permitted the property to be completed then?
Your Honor, I started to represent this particular client 3 days before the development rights were to expire. So I was not intimately involved in any way up to that point. And my job was to find what I did find, a clause in the master deed that gave the developer almost unlimited right to amend the master deed in any way they seem fit, except for that there was a condition in that clause whereby the amendment would not substantially increase the burden of any unit owner or substantially decrease the benefits of any unit owner. And I'm submitting to this court that there was no evidence before the land court of any decrease in benefits or any increase in burdens for a few reasons, which I will explain in a minute. And number two, that even if there was some evidence of something like that, then it wasn't substantial. There's no evidence of the substantiality of it. And the condition is that the amendment shall not substantially increase the burdens of any unit owner or substantially decrease the benefits conferred upon any unit owner.
Okay, so the first thing you have to do is you have to address why isn't, as a matter of law, doesn't Suprenant say that that's exactly what this extension does?
Yes, Your Honor. I was a prevailing attorney in Suprenant, and this is a little bit different than, in fact, it's a lot different than Suprenant. In Suprenant, what you had was some new developer coming in, changing the footprint in effect, and changing temporally the condominium documents, the percentage interest and so forth of the unit owners. In this particular case, the unit owners purchased knowing that, number one, their percentage interest would be changed when units were developed. This is nothing new. And in this particular case, there was a specific provision in the documents allowing the declarant to unilaterally amend the master deed. They purchased into that scheme. And this was not present in Suprenant. And so they knew all along that their percentages were going to be changed in the event that new units were added. This was nothing new to them. They suffered no detriment or anything. The only thing was a question of timing. But again, when they purchased the units, they purchased knowing full well that the percentages were going to be amended. So this is different than SuperNet.
So, but I mean, so as 7 years is coming and you're being quick, call Attorney Goodman, better call Saul. We need to, if you don't do something, the unit owner's rights are going to become fixed. But why, why didn't the thing they bought into 109 units within 7 years?
Because, Your Honor, they purchased with the understanding that the documents could be amended at any time in any way. So the question here is not whether the documents were, whether they didn't know and buy into the scheme that the documents were going to be amended. What they did buy into was that they wouldn't be, and this is the real question, whether there was going to be any increase in burdens or decrease in benefits. That's really the issue, and whether they were substantial. And I'm submitting to the court that there was no evidence of that before the land court.
So one of the things that would happen is you created a new class of a new Class B trust, which suddenly had more voting rights than all of the rest of the unit owners. Why isn't that something that substantially affects their rights?
Well, first of all, Your Honor, if one were to look at if one were to look at this trust, this voting trust, one would see that what I did was I set up a buffer where the language, the specific language right within the trust states that the units would pay any increase, if there was an increase in common fees or common expenses or anything like that, into the trust, and that the trustees, so that the existing unit owners would suffer no additional burden. This was a buffer. It was not as is being argued, it was not a separate condominium trust competing with the existing trust. It was merely a trust to hold these units and any obligations that these units might have that would exceed anything in the original trust, so that the unit owners would not suffer any detriment or decrease in benefits.
There's language in the Fifth Amendment that seems that the judge read as doing the opposite. Can you explain? Can we take a look at that, and can you explain to me why the judge read it wrong?
Well, I don't know what was in the judge's mind, Your Honor, but that was the intent of this. Now, what I would suggest to this court is, if I am correct that my client had the right to amend the master deed to extend the development rights, then I think that this case itself, the decision of the land court on that issue has to be overturned, that my client does have the right to continue to develop.
Can I ask you a question about your interpretation of this section 11, section A?
Yes.
It says that while the declarant owns any unit in the condominium, or during any time in which the declarant retains the right to add in additional units, they have the right to amend the master deed, basically. As I read that, you would say that even if the LLC continues to own only one unit, they unilaterally can control the terms of the master deed because they own the power to, they hold the power to amend it unilaterally. This could continue forever under your interpretation, no? And doesn't that run counter to to our basic understanding of a condominium setup. Is let's say you retain one unit, well, you retain one unit now. So as I understand that your argument, the developer still retains the power to amend.
I am running out of time.
You're out of time.
I'm out of time.
Yes. Okay, thank you.
Thank
Mr.
you.
Tinsley. You have to unmute yourself.
Pardon me. Good afternoon, Your Honor. I represent the lenders in this matter, Commerce Bank and Haymarket Capital. The issue in our appeal has to do with the extent to which the mortgage continues to burden this condominium property, or the extent, if any, to which it's been extinguished. I agree with Attorney Goodman's representation earlier that the mortgage should not be considered to be dead. The mortgage has not been satisfied. It has not been discharged. So to the extent that the mortgage burdens those development rights, the mortgage should be considered dormant in the same manner as the rights themselves are dormant, and should they be revived at some future point, the mortgage should be considered revived.
Can I ask you, what if we were to agree with you that you did not release all your rights, but we were to agree with the judge that the developer did not effectively extend its rights to continue the phasing? What does that leave the banks?
I think that leaves the banks. Well, I think that fact pattern, I believe, Your Honor, leaves the banks where I just mentioned, that it leaves them with a continuing mortgage right held against development rights that are dormant at that particular point in time. I think there's an analytically distinct issue that's relevant for my appeal, however, and that issue has to do with whether this particular phase, these phase 4 units, this 56 partially constructed, substantially completed units, whether those should be considered condominium condo area, and therefore the lender's interests have been dissolved or waived by virtue of issuing those partial releases, or whether those 56 substantially completed units should not be considered part of the common area and therefore are separate, and subject to a separate analysis. That's my point of view, Your Honor. So my point of view is that the common area.
Before you get there, is that the point that Attorney Moriarty says you didn't raise below?
Yes,
Okay.
Your Honor.
Did you raise it below?
Well, I didn't do it personally, Your Honor. I was only brought on as appellate counsel here, so I didn't handle the argument below. Substantially, yes. I don't want to quibble with Attorney Moriarty in this sense. Broadly speaking, Your Honor, the argument was not raised below in exactly the same way that I've raised it in the brief. That much is fair comment. I think the substance of it, though, is still there. Here's one of the key considerations when thinking about this notion that we're raising brand new arguments and they were sort of unfairly prejudicing the condo association here. And I think there's even a request for fees or other relief in connection with that. Here's the thing, Your Honor. All the cases, if you look at the cases that talk about an appellant's inability to raise new arguments on appeal that weren't first raised at the trial court level, the gist of those opinions always has to do with the fact that the appeals court doesn't have a sufficient record in front of it to make a decision on these issues. If they weren't first raised below, the record will be bereft of any information that would suffice to adjudicate the dispute. But that's not at all the case here. We're talking about specific language in one section of Section 6A of the master deed, and that section is analyzed at length in the underlying briefs and in the court's decision. But here's what happens, though, Your Honor. When the court issued its decision on summary judgment, Section 6A was quoted, but it was quoted only partially, and the court used ellipses to indicate that there's a chunk of text that has been omitted by their quotation. But that's precisely the chunk of text that I maintain is controlling. It speaks directly to the issue at hand. So my point of view is that we haven't really introduced new arguments or new material in any real sense, Your Honor, because we're still grounding our argument directly in the text of Section 6A, and
Okay,
Section 6A is cited by the court.
You're talking about the last sentence of 6A?
Yeah, it's actually, well, let me see, Your Honor. Is it, I think the last two sentences, Your Honor. In the event of construction.
It mentions something about being specifically labeled, that is, which leads me to look for, is there somewhere in the record where there's like a diagram or something that says condos, common space, other? I mean,
there are drawings, I believe, in the record, Your Honor, but I am not aware. I guess let me answer it that way, Your Honor. I'm not aware of anything in the summary judgment record that satisfy, that sort of speaks to the language in this section where you're seeing areas that are specifically labeled. And I don't think the summary judgment record is clear, Your Honor, on where these specific labels would be manifest. What document or other material does this master deed contemplate would be the vehicle for articulating those specific labels? I don't think the summary judgment record is clear. It's one of the points I make in my papers, Your Honor. But just circling back to this notion that this is sort of a new argument that's sprung out of nowhere.
Let's talk to the substance. Let's get beyond that.
Okay.
But you're telling me, so there's, what are you saying then? You need a trial to figure out what that sentence means, to figure out which are the areas that are not fish nor fowl?
I don't think we need a trial, Your Honor. I think it could be resolved on summary judgment. I just don't think the summary judgment record that we have is complete on that issue.
So there's nothing in the record that points to what's this unaccounted for area?
Not that I'm aware of, Your Honor.
Could we go back to Justice Massing's question about the what would be the effect if we were to hold that the developer did not timely exercise his rights, but that the banks or the lenders still have dormant interests through the mortgage? In your view, in that circumstance, who has what happens? There were, as I understand it, some property purchase loans and then some construction loans. Is that correct? The mortgages were not all of the same. The mortgages may have been the same, I don't know, but the loans themselves were not all of the same type. Is that correct?
That's not, I don't know that you're referring to my client's loans or other loans, Your Honor.
Your client's loans.
No, I think they're construction loans, Your Honor.
They're all construction loans? Okay, and they were secured by mortgages on the land and buildings?
Correct.
They were, and that was after the purchase of the property?
That was, yeah, those mortgages were issued and recorded prior to the condo master deed being recorded, which I think is kind of the pertinent point for getting the chronology, yes.
So if the mortgages under your theory become revived, who owes your banks what in order to discharge the mortgage? Who has liability? Well,
it would be it'd be the borrower in that case, Your Honor, and so you're talking about the LLC at that point.
So if a new developer is brought in to complete the development, it's still the original LLC who owes on the liability to your clients? Is that correct?
I think it would be, it would, well, no, not in that case. You're saying if it's a third party It's not the LLC that revives the development rights. It's another developer, Your Honor.
It's got to be the association at this point that would be reviving the development rights.
Right. So I think to anyone acting under color of those rights would be their interest would be subordinated to the mortgage the same way that the borrower was. So yes, I think at that point the condo trust, if that's the entity that's exercising those development rights, would be subject to the repayment obligations under the mortgage. I mean, the condo association can't obtain the rights without the corresponding obligations coming. I mean, I think those are an inseparable package, similar perhaps to the way that the common areas and the units are an inseparable package in the
Well,
eyes
it
of the
seems
law.
to me then you run into the problem of all those partial releases.
And pardon me, Your Honor, but what's the problem particularly?
The problem, I guess, the partial releases are given to the individual unit owners, correct? But
Correct.
but also what they release is not only the lender's interest in the unit, but also in the unit's interest in the common areas, correct?
Yes, Your Honor.
And if we accept that all of the undeveloped area reverted to common area, which is what the judge found, then arguably when you partially released each unit, well, you released each unit in full. It was just a partial release generally, but I'm going to call it a partial release.
I accept that point of view, yes.
So when you released each unit and it's a pertinent interest in the common area, you've now released arguably almost all of the common area.
Well, I think that's a key. Pardon me for jumping in, Your
Honor. No, I'm grateful that you jumped in.
I think that's a key point. You may recall from my papers. That's one of the ways I try to distinguish this case from Beechwood, because what happened in Beechwood is that the lenders issued partial. By recollection, it was 3, I think, Your Honor, and those 3 units collectively owned 100% of the common area. It was a third, a third, a third. So in Beechwood, when the lenders executed those partial releases, so-called, it was in effect a complete release with respect to the property. But that's not the case here. So the lenders at all relevant times have retained at least 1 and perhaps as many as 5 unsold units, each of which also has an interest in the common area. So the mortgages do continue to burden the common areas by way, at a minimum, they do so by way of the lenders continuing to own, or pardon me, the developer continuing to own unsold units that are subject to those mortgages. And I think that's conceded.
That, but it seems to me as a practical matter, it's almost like holding this association hostage, because the 53 unit owners, they've gotten releases. If we accept the judge's reasoning as to what's in the common area, your mortgages only burden a very small percentage between whatever units of the common area. That all seems to me to make sense until you say that, well, if the association decides to develop the undeveloped, the unfinished portion of the project, then all of the liability is going to be revived despite the previous releases. It seems to me to essentially create a complete impediment to the future development of the unfinished portion of this project.
Well, I guess maybe, Your Honor, I mean, a couple things, I suppose. One is that maybe this is a good entry point into the question, though, of whether these additional 56 units should, in fact, be considered part of the common area, because I think that's really the critical issue here. That's really where the windfall comes in. This is the condo association is essentially getting 56 substantially completed condo units dropped in its lap for nothing. And meanwhile, the lender has $12 million outstanding on this project that hasn't been repaid. So that's where really the gross inequity comes in. And that's why I've encouraged the court to consider the language here in section 6A that the trial court omitted from its analysis and cut out when they quoted this section, because here's what it says. In the event of the construction of additional phases, so that's what we're talking about here, though this is a phase 4 construction, the declarant, which is the LLC, may submit those units contained in any additional phases to the condo by amending the master deed. And I'll omit some language here and just get to the bottom line. Until such time as an amendment is recorded, any portion of said building or real property not specifically labeled as either individual unit or common area shall remain the sole property of the declarant. So again, that word remain, for example, I think is critically important to attend to in that sentence. This property that we're talking about, these unfinished units, were never intended to be part of the common area from the very beginning. They always remain with the LLC until and unless the master deed is accordingly amended to accept those units. And since it has been the condo association's position yes.
Unless there are any questions, we're going to hold you there. Seeing nothing, thank you. Mr. Moriarty.
Your Honors, may it please the court, I'm going to start my argument today on behalf of the Kettlebrooks Law Condominium Trust and all the appellees, responding to certain questions that have been posed to the LLC and the Lenders Council. First, with regard to this amorphous dormancy suggestion, not only did the lender not raise that below, the lender didn't raise that in its briefs before this court. But what's more, as to the substance, Your Honors, the concept that the declarant could give something to the banks that was more than the declarant had is anathema to 150 years of common law. The fact of the matter is what the declarant and the banks are now claiming is that if the declarant's 7-year phasing right completely disappears, that somehow the bank could have something more after that 7-year period expires. But the reality from a legal perspective is if the declarant could claim no right to the phasing rights after the expiration of that 7-year period, then the lenders could claim no right, dormancy, existing, or otherwise.
But what's the more? I'm not following what's the more.
Well, Your Honor, it's the declarant and the bank's argument. They suggest that there is some dormant right that would spring back into existence.
No, but assume that that's correct. What are they getting more than they had on the day while the LLC's, let's take things the day before the LLC's development rights expired.
They have,
as of that date, comparing that date and what the bank is arguing would happen if, some dormant interest revived upon a new development, what would they have that's more?
Sure. So what they would have the day before is an interest in a phasing right with 1 day. What they would have after July 22nd, 2015 is any interest in a phasing right. That dissipates. It ceases to exist on July 22nd, 2015. If the banks have any interest in a phasing right after July 22nd, 2015, they have more than what the declarant had. The declarant only had a 7-year phasing right, which became utterly and completely valueless as of July 22nd, 2015. Therefore, the banks could have no interest whatsoever in a phasing right, present, dormant, prospective, in any way after July 22nd, 2015.
I mean, but what if, is that maybe overstating, because doesn't the declarant still own a few of the units, and aren't they one of your group of, don't you also represent them in a way as they're the unit owners of one to 5 units?
That's a different question, Your Honor. What the declarant and the banks are arguing in this context is that they have a dormant interest in a phasing right that may be revived after July 22nd, 2015. What this court is appropriately recognizing, and what my clients concede absolutely, is that the mortgage is not invalid. The lender's mortgages are not invalid. They continue to have an interest in any right under the master deed that has not expired. And they also continue to have an interest in any unit that is owned by their borrower. Now, the fact that their borrower also has an interest in the common area through its ownership of a unit cannot be confused with the question of whether or not the lenders have a mortgage directly on the common area. Any bank that takes a mortgage on a unit takes that undivided interest in the common area. So every one
What's
of
the language in the mortgage specifically regarding the interest that it burdens?
well,
Can you
interestingly,
point to
Your
me
Honor,
to the page?
there's nothing in any of the mortgages by which they take any interest through the condominium. There are,
What is the language? Maybe you can point me to the page in the record.
Your Honor, there is nothing in any of these mortgages which references in any way interests that were created through the recording of the master deed or the declaration of trust. They are completely silent. The argument.
They say nothing whatsoever about what interest is burdened by the mortgage? Nothing. You're
Oh.
telling me there's not a single word in there that says what the mortgage is attached to?
Your Honor, my apologies. I thought you meant relative to interest in the condominium.
Nope, I'm looking for, and I'd appreciate a page.
The land and buildings, Your Honor, each one of the mortgages references 1511, and I believe it's 1534 Main Street. And the mortgages I will give you, and this is using 739, the appendix in 739.
Yep.
Volume 3, page 108, that is the first mortgage to WA funding. Volume 9, page 42, that's the second mortgage to WA funding. Volume 9, page 28 is the third mortgage to WA funding.
Yep, and you're saying they all have the same language?
Not identical, Your Honor. In fact, the first mortgage only references 511 Main Street. So that one that was recorded at volume 3 at page 108 of the appendix, that only references 511 Main
So
Street.
now, when it defines premises as all buildings, structures, and improvements now or at any time in the future
Yes.
on the land, that doesn't matter?
Oh, no, it would matter completely, Your Honor. It would be controlling, quite frankly, had those mortgagees not recorded after the recording of the master deed, partial releases of their interest in the units. Because all of that land that's described in every single one of those mortgages is the land that was submitted to condominium status and is the land owned 100% by the unit owners. So there is no question, absolute concession, Your Honor, had the banks not recorded partial releases of the units, the banks would have a priority lien that when foreclosed, in fact, would wipe out the condominium association. But of course, that is the precise reason in this business context that the bank would have issued partial releases. The bank gave construction loans to its borrower, the declarant. The declarant creates a condominium association and can only repay its lender by selling those units. In order for those units to be marketable, to be saleable, to be mortgageable, they must not be capable of being wiped out by the foreclosure of those prior recorded.
At the time the partial releases were given, had the development rights on the remaining 56 units expired?
No, Your Honor. The development rights on the remaining units did not expire until July 22nd, 2015. So under the defendant and the lender's theory, and the the trust would accept this argument for purposes of the appeal, that when the master deed was recorded, although the mortgagor could not encumber without the consent of the bank's interest, that once the units were created, that the bank could fairly claim to have an interest in those units. And once its borrower, the declarant, reserved rights in the master deed, that it could claim to have an interest in that reserved phasing right. But, Your Honor, the trust point is simply that it can't be anything that goes beyond July 22nd, 2015, because that's all the declarant reserved to itself.
So to go back to my question about the day before the development rights expired, the lenders actually had much more because their partial release than what you answered, I think, in all fairness before, because the partial releases would not have affected the lender's interest in the units that were subject to the development right, correct? So
No, Your Honor.
no,
Not the units that were subject, because there were no units. The only units that existed are units that were created. And that's an important distinction because the lender claims that there are somehow 56 units out there. Well, there aren't. There were only 53 units that were created.
okay, the
But-
56 that had not yet been phased in.
Yes.
I take your point, but the day before the development rights expired, the lenders had, what I hear you saying is that what really extinguishes the lender's rights, and I don't mean extinguish absolutely, let's just call it, you know, the big part of them, is the fact that the developer did not timely exercise its development rights.
That's fair to say, Your Honor. There are a couple of observations packed into that observation, Your Honor. But the way the trust would characterize it is that one of the critical instruments were the partial releases. And after the partial releases were recorded, banks still had interest in units and phasing right. Then the phasing right expired. So bank no longer has interest in phasing right. Bank continues to have interest in units and that unit owner's percentage interest in the common.
So,
Is that not what the second judge found? The judge found it was completely extinguished, right?
No, what the phasing right is completely extinguished. The mortgage is not completely extinguished. The only thing that the trust asked for below was to extinguish the mortgage as regards its coverage of the common area. The point with regard to the phasing right was, well, there's nothing to extinguish.
Okay, but with respect to the common area, though, they still have, they haven't released 100% of the common area.
Oh, yes, they have, Your Honor. In fact, when they issued their first partial release, and this is right out of Beechwood, when they issued their first partial release to that first unit owner, they told that unit owner that its unit, together with 100% of its undivided interest in the common area as a tenant in common, is released from its mortgage. So
But it only had that mortgagee only had a 1/33rd interest.
no, Your Honor.
And that Beechwood had, and I was on the panel of Beechwood.
I know.
It had three, the thing was that they released all three of the first phase. They released the entire first phase. Here, they didn't release all 33 of the first phase.
No, the distinction, Your Honor, is not with regard to the number. You are absolutely correct, obviously. They did release all three. But the controlling point is not what units might still exist that also have a percentage interest or whether those units have been released. The point, Your Honor, is not did all of the unit owners get a partial release? And that's not what came out of Beechwood. And I understand, Your Honor, I argued the case. I know you're on the panel. The distinguishing point in Beechwood is that you could have taken even one of those initial releases, Your Honor. Any release releases 100% of the common area because each unit owner owns an undivided 100% interest in the common area as a tenant in common. So playing it out practically, Your Honor, once that unit owner is told that we are not going to dispossess you of your interest in this unit because we have completely released your unit and its ownership interest in the common area from our mortgage, the mortgage can never be foreclosed in a way which wipes out the condominium, wipes out the master deed, or takes a single bundle of sticks out of the interest that was submitted to the condominium, because that's owned 100% by that unit owner. In fact, the Beechwood case, Your Honor, while it points out that at the inception, when the first partial releases were granted, the Beechwood court goes on to say that with each successive partial release, the same thing happened. So there's no significance to the fact that all three then existing unit owners were partially released. The fact of the matter is, if any unit owner is partially released, their interest in the common area is also partially released, or is also completely released.
Can we go back to the very beginning of the story, if you would? And I'm going to ask the same question I asked Attorney Goodman, which is, how did we end up here? It seems like a very odd and undesirable place, to be frank, to have part of this. It's a single building, right, with different phases within it.
There are wings, and there is one detached structure.
Okay, so to have a partially completed condominium development seems to me not what people had in mind on any side of the equation. And how was it that instead of allowing, or why was it instead of allowing the developer, even if one were to say that the association is correct or the trustees are correct, that the development rights ended after the 7 years, why wouldn't you have preferred to see that completed? What happened here?
So, Your Honor, I can't say that any of what I'm going to say is in the record before this court, but I can say practically that there were disputes between this declarant and the association. The association was concerned with the quality of the construction and the conditions of the common areas that had been submitted, and my client was not inclined to allow this declarant to continue to undertake construction activity on the common area, for which it would have been responsible in the event that there were, as were alleged by my client, additional deficiencies with regard to the construction practices employed.
So how do you get around section 11A, which basically says as long as the declarant owns anything, they can unilaterally amend?
Two ways, Your Honor. In the first instance, Supernant is directly on point. Supernant stands for the proposition that a general amendment provision cannot be relied upon to extend a phasing right. So that section 11 provision is just one of the general provisions of amendment that are provided in the master deed. And the fact that there's an exception for the developer to do something unilaterally doesn't give the developer any more authority than the law would otherwise allow. What Supernant says is that in connection with an extension, it changes and alters the percentage interest of the unit owners, that when there is a 7-year, in this case 7 years, and there was in Supernant as well, but if there is an expiration of a phasing right, upon the expiration of that phasing right, interests become fixed, and therefore any extension that is unilaterally executed by a declarant relying on the, or even is in Supernant with 70% of the unit owners, is a end run around 183A 5B. 183A 5B, which provided when Supernant was decided, which has been amended over time, but still has the exact same operative language, provides that a unit owner's percentage interest cannot be altered without that unit owner's consent. So the suggestion that the developer can rely on even a broadly worded, and I don't concede that it is broadly worded, Your Honor, but if it was a broadly worded reserved general right to amend the documents, it can't be employed in this context. The fact of the matter is the law established by the court in Supernant stands for the clear and unequivocal proposition that a unit owner's percentage interest cannot be modified by an extension without its consent. And Supernant is on all fours here. I know that the declarant suggests that the Supernant case was a revival case, that somehow the Supernant case involved a post-expiration amendment to revive the phasing right, but that is simply inaccurate, Your Honor. I know that the declarant's counsel was involved in that case, but the facts are in 1991, an extension amendment was signed, and in 1993, the phasing rights expired. It's the same factual circumstance here. But in addition, Your Honor, even if Supernant allowed the use of a general amendment provision like Article 11, in this instance, there is a check on what the declarant can do. The declarant can't do anything which substantially increases the burdens on or substantially decreases the benefits to a unit owner. So in this instance, the unit owners buy with the understanding that the phasing right is going to expire in 7 years. Their ownership interest will become fixed in 7 years. The ability of the declarant to occupy the additional wings that are subject to that phasing right cannot be occupied after July 22nd, 2015. The unit owners would not have the same level of control over the association if additional units could be added after July 22nd, 2000.
On the before the development rights expired, the undeveloped portions of the property, in your view, and then I'm going to ask you on what basis you hold that view, were those portions of the property common area or something else?
Common area, Your Honor.
And where would we look and see that answer?
So you will see that in Article 3. You will see that in Article 11.
So when we see references to the developer either controlling or owning that, then how do we interpret that?
Your Honor, quite frankly, there are no references to the developer owning or controlling any portion of the land or buildings that were submitted to condominium status when the master deed was recorded. Not one. The only reference that you will see is work on units that may have been done in connection with the exercise of the phasing right. So in this instance, you'll see photographs in the record. There were some stud walls added after the submission of these buildings to condominium status. The only argument that the declarant or the lenders could have with regard to Article 6 is that those elements, those individual elements could be something other than common area during the period of time that the phasing right existed. So they added some wood, basically some stick frame 2x4s were added to the common area that was submitted. That paragraph, Article 6, could arguably stand for the proposition, Your Honor, that the elements that were added didn't become fixtures. They didn't become part of the common area until the units were submitted, and so that the developer retained an ownership interest. Now, from the trust perspective, Your Honor, as soon as those elements were attached to the common area, physically, mechanically attached to the common area, they became fixtures, and they were part of the common area. And I understand that Article 6 then creates a question of, well, if you have an element that's affixed to land, how would the developer continue to assert an ownership interest in that element? I don't think that that can be reconciled, Your Honor. In that regard, I would say that the law with regard to fixtures would have to be controlling. But if you assume that the declarant and or the lender could claim an interest in those wards, for want of another way to characterize it, it certainly does not change the reality that they have released everything that was otherwise submitted to the condominium.
So I cut you off before you could answer the question of what is it in the documents that states that those undeveloped areas were common area while the development rights were still alive?
So there are several spots in the master, Your Honor. Article 3.
Let me look. I'm right there.
I'll see if I can get a more specific.
Is that just because it's the
description.
general thing that says the land and buildings and
Yes.
improvements?
Yes, Your Honor. Article 3, and then Article 9. I'm sorry, Your Honor. Article 3, Article 11.
I don't know about Article 3 doesn't define common area, does it?
It says that all of the units, all of the buildings and units are submitted to condominium status, Your Honor.
Sure, but does that necessarily carry with it a designation of which portions are common area versus units?
Yes, Your Honor.
Okay.
All of them, but so the master deed defines unit and it defines common area. But the master deed itself submits all the land and buildings in very detailed language. And
I take it that everything is submitted to condominium status. I get that.
And that means it's either common area or unit. And the way the master deed defines the common area is
That's what I'm trying to find out.
Everything but the units. That's how the master deed defines.
Okay, so it's sort of a default. If you're not a unit, then you're common area.
Yes, Your Honor. And I know that the declarant tries, or the lender rather, tries to fashion an argument that by defining the common area as everything but the unit, the fact that the unit has an appurtenant interest in the common area creates this circular reality that is.
And where is the definition of common area?
Your Honor, I am not.
It's Article 6. Article 6. It's a long list.
Okay. All right. Thank you.
And the argument is that by defining the common area as everything but the unit, because the unit has an interest in the common area, that the master defines the common area as everything but the common area. But the trust argument is there is a distinction between ownership in the common area and describing the physical space that is unit and common area. And the master deed has to do the latter. The master deed has to indicate what is the common area and what are the units. The question that's presented on appeal is what is the ownership interest possessed by the unit owner? And that we think is satisfied by well-settled law. It's 100% of the common area, undivided as tenant in common.
So if we affirm the judgment here, what happens to this unfinished condominium with the 50, the studs in the walls and the graffiti or whatever?
That depends on what 75%, or I could say 25.0001% of the unit owners decide to do. The reality is 100%. I'm sorry, Your Honor.
Because they have the filibuster power.
Well, they can prevent the unit ownership from getting to that 75%. So under 183A section 5B23, the trustees, together with 75% of the unit owners and 51% of qualified first mortgagees, can vote to revive the phasing right and can grant that phasing right to whoever they want. So however, the unit owners could decide we don't want to do anything with this. The unit owners could decide it is not financially feasible to further develop. They could remove portions of the building. I mean, they'd have to get a vote to do it, but there are a lot of options. But what they wouldn't be compelled to do is to accept this declarance further development of the project. There was one question that I wanted to get back to, Your Honor, with regard to the lender's arguments under section 6A. That's the idea that this labeling of the common area. Now, the lender's counsel says that it's not a material deviation from what they argued before the land court. But lender's counsel also points out there was no developed record on summary judgment before the land court. And on that ground alone, the land court's decision should be reversed. The lenders can't have it both ways, Your Honor. The reason that the question of labeling is not presented or was not presented to the land court below is because the lenders didn't raise it below. So they're saying on one hand, well, this isn't material, this shouldn't impact anything. It's essentially our same argument. But on the other hand, based on that very claim, they're suggesting this court should reverse the land court and send it back because there wasn't an adequate record on appeal. The last point I would make is they don't, however, claim a trial is necessary. So even if this court were to agree with that, it could look at labeling and conclude that the master deed labels the common area in spades. It's everywhere. It's identified and it's clear what the common area is. Thank you, Your Honor.
Thank you all.
Thank you. I'm
Interesting case.
I was
Interesting
muted.
case.
Thank you. Thank you. We'll take it under advisement.
Thank you, Your Honor.